You're Marcus Elim, and Mr. Elim was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation for burglary and habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections to the report? And it was unagreed. Mr. Lewis, you may proceed.
Judge, this situation when it's so down so you see while you had probation, not following the obligations. After speaking with him, he's going to try and leave. He therefore, on what he's telling me, willing and wanting to provide his court orders and physical operations to get opportunity. He understands his mistake. That's cost for him and his decision here to attack him. And of course, he would like to drink before the moving forward.
Alright, go ahead.
It's just for my actions, I feel no probation.
Here, the defense's move humanize the defendant. They're pointing to grief, family loss, and emotional hardship. Classic mitigation strategy. But in court, empathy can only go so far, especially when the record shows repeated absconding.
Okay.
Again, if I may, one of the biggest issues I blamed the cops about was him not reporting to standing back. He expressed to me that at that time he was dealing with the death of his grandmother. He saw it, I think she's a big part of the support system. He does have several members of his family have contacted about him, so he does have support system that she's part of. And she passed away. That's kind of what created that point.
What is the status of the 5 new officers? What happened? So, what was the deadly conduct from August 2023? What was the outcome? I guess I'm trying to figure out what happened on all of them.
My understanding is that he had taken the opportunity to meet me for nothing here.
He pled true to the deadly conduct discharging a firearm from August 16th of 2023. Yeah. Here you go. Sorry, did you jump in? Right after he pled true. No, I just want to know if I want to know that. I want to know what's the evading, the failure to ID from February of this year. I want to know what the status of everything is. I mean, he pled true to it, so obviously, yeah. All right, Melfino, what's the state 3? What was
This is
the
where things start unraveling. Prosecutors
Yes, I'm trying to figure out what
basically
happened on all
he
of
didn't
them.
just disappear for a few weeks. He ghosted probation.
My understanding is he had
Imagine being on the run and stacking up new charges. Every new offense adds weight to the sentence waiting at the end.
Just torn on concerning major conflicts content because other two they were for her 2 years, year and a half late in our country, regardless of the having been filed or used or whatnot by take division. He has led through to at least court standards and having kind of all the things off swallowed from his fellow. Has no felony convictions. It looks to me like he ordered him to IHS college in 23. Yeah, Mr. Lewis had made mention that he never went. I don't know if they didn't have a bank for him and eventually he timed out of that or what happened in the new office. He came up and said, "Thank you."
think when he had prior entry up, I hope we could look at new case on prior entry here. I'm not sure, but I accept order. But at some point, I guess after find out he's released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to leave going to the time, and he was going to complete more recreation therapy and went out, but
So it was the new offenses that had been before holding him up.
Correct.
You get an opportunity to be on probation for burglary of a habitation. And I want everybody to make sure I've got this right. So you get deferred probation for burglary of a habitation, second degree. You get out, you commit 3 new offenses. 2 deadly conducts, discharging a firearm, and an assault family violence on that same. Regardless of what's come of those cases, you've admitted that something happened on those days, right? So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISI. But because I guess something else must have been pending, any misdemeanors or something, you don't go to ISI. So you end up just getting out, getting another opportunity, and then you go and stay arrested detention and felony.
Here comes the judge's breaking point. She's walking him through every chance he's already had. ISF programs, deferred probation, sentences, and every single time he blew it. This is the moment where courtroom patience turns into consequence.
Do I do? We're back here again. And you want to start over, you're sorry. Think about how that sounds. And you just quit going for 2 years. A year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know? I mean, how old are you now? 23. You started this when you were 19. So like you're not taking advantage and you're not growing up and making better decisions.
Okay, right. Work with them for him to show up. Mark was showing me. I have a jet application here today.
I mean, I don't know that it makes sense for me to do anything else. I mean, this is just so frustrating, honestly, for me. For the young people, keep coming in here with offenses that have to do with shooting. While you're on probation for a felony, you're shooting. Then you get out again, and you violate again, and you take off. So I can't give you a 4th shot. You've had your shot. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections.
Boom, 6 years in prison. The hammer drops. The judge's frustration is clear. How many second chances can one person get before accountability kicks in? Notice how she calmly transitions into firearm restrictions, because once convicted, even owning a single bullet is a felony.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. Good morning, sir. You're Chad Michael Holland. And Mr. Holland, in cause number 24, DCCR 1616, you're charged with a 3rd degree felony offense of fraudulently securing documents by owner. And the D section, but it says executed documents. Anyway. And that offense is from December 30th, 2023. Your indictment alleges that you were previously convicted of burglary of a habitation March 15th of 2004 And after that was final, you were convicted of fraudulent use of identifying information, October 7th of 2020, and also possession of a controlled substance, second-degree felony, October 7th of 2020. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum.
And just when you think the courtroom can breathe, next case. Mr. Holland steps up, facing 25 years to life if convicted. Stakes jump from probation talk to high-risk felony territory. This is courtroom whiplash at its finest.
25 years, up to 99 years for life in prison. Do you understand? And I have a plea bargain rejection here that shows that the district is... What's going on over there? Everybody needs to, if y'all are going to be here, you need to sit up straight in your seats. We can get you a comfy seat up here if you want to come be closer to the action. But if you're going to be here, you don't sleep in court. That's disrespectful, okay? Just sit up. Get your hand off your head. Everybody sit up. Eyes open. Pay attention, please. So, I have a plea bargain rejection that you've signed with Mr. Gertz. Shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be pleading to counts 1 and 2 only for a 15-year term in the institutional division, Texas Department of Corrections. Do you understand what your possible consequences are if you go to trial and what your options are? Do you want to reject that offer and have your case trial? Yes, sir. Okay. Sure. And y'all talked about that. So, Mr. Holland, I want to make sure you...
DA drops a bomb, a one-time plea deal for 15 years. Reject it now, that door closes forever. This is what legal strategy looks like in real time, gambling with decades of freedom on a single decision. Would you take the deal or roll the dice?
Understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different than this, to the indictment with the minimum 25, unless there's new information or evidence that comes to light that either Mr. Garcia or Mr. Connery don't know about the case. Do you understand? And you want to reject that offer and go to trial, correct? All right, we'll get it set on the trial docket. Mr. Garcia will begin preparation.